Hey everybody, welcome back to Guns and Gadgets, your source for Second Amendment news. Please excuse me, I'm exhausted, just got done moving some furniture. It's been 2 long days of work, but I did want to point out something to you. I'm holding this with my hand, so I apologize for the shake. Chicago area, Cook County in Illinois, there was a challenge to the assault weapon ban, and yesterday the U.S. Court of Appeals for that district, which is the 7th Circuit, they upheld it. They refused to hear or even consider arguments by our side, and I'm going to read you what they said because it tells you what's really going on and what we're going to be facing come September 9th when our senators and our congressmen come back from break. It's just another example of how lower courts are thumbing their nose at the U.S. Supreme Court's Heller decision and basically just trying to destroy the Second Amendment here. So I'm going to read you a little bit here, and you'll see what's coming. So this is from the AP, and Michael Tarm had this article today, and I'll try to link it if I remember. But a U.S. Court of Appeals Thursday upheld an assault weapons ban that covers Chicago and the rest of Cook County, Illinois, saying gun rights advocates provided no compelling reason why it should diverge from a previous ruling upholding a similar ban in a Chicago suburb. This ruling was unanimous. I'll have a link to the 17-page decision if you want to read that there. And this ruling is binding for all the states in the 7th Circuit, which would be Illinois, Wisconsin, and Indiana. And the quote from the decision that I saw was, quote, "We have stated repeatedly and recently that absent a compelling reason, we will not overturn circuit precedent." So they're saying they won't overturn any assault weapon bans, even though they're unconstitutional and illegal. So that says a lot. The previous ruling that they are talking about was from Highland Park, and it was a 2-1 decision on that one. And the quote that came out of that one was, quote, "If a ban on semi-automatic guns and large-capacity magazines reduces the perceived risk from a mass shooting and makes the public feel safer as a result, that's a substantial benefit. So feelings supersede my civil rights." Really? Now, the one vote for the Second Amendment in that case, that was Judge Daniel Mannion, and he said, "The right to self-defense is largely meaningless if it does not include the right to choose the most effective means of defending oneself." That was eventually appealed to the U.S. Supreme Court, and they declined to hear it because they weren't taking up any Second Amendment cases for far too long. Now, yesterday's decision about Cook County will be appealed to the Supreme Court. Maybe this court takes it up, maybe they don't. So this ruling was unanimous, and one of those judges is a Trump-appointed judge. Her name is Amy St. Eve, and another judge on that panel was appointed by Ronald Reagan, Kenneth Ripple. The third judge is a Bill Clinton appointee, David Hamilton. So 2 Republican-appointed U.S. District Court judges just turned their nose at the Second Amendment and said, you know what, unless you really, really make us believe we should overturn it, we're not even going to try. Dangerous stuff. We've got a big fight ahead, guys and gals. And if you like me bringing this type of information, you enjoy knowing what's going on without the mainstream media telling you, you have to subscribe to this channel because this is where you're going to get it. So please hit that subscribe button right down below. Like this video, share it if you would, and hit that bell icon so you'll get more information of when I put out these types of videos. I appreciate your time. Thank you for for understanding my situation here today. I'm beat, but this needed to get out, and I hope you'll share it for me. So until we see each other again, I'm Jared, your humble host of Guns and Gadgets. Be safe, stay vigilant, carry a weapon. Have a great evening, everybody.